Good morning. I'm Michael Polyakov, Vice President of Policy for the American Council of Trustees and Alumni. I'm delighted to introduce Professor Philip Hamburger, the Maurice and Hilda Friedman Professor of Law. You'll notice that he wrote already for us a very important commentary. This is in your book on the AAUP Statement of Corporate Funding, key document number 6. So I'm going to flip the order slightly of events. We won't start with academic freedom and tenure. We will start with Professor Hamburger using his quintessential style of teaching in law school, conducting us through a discussion of research misconduct and academic freedom. So I'm going to turn this over now to Professor Hamburger.
Thank you very much. It's a pleasure to be here, and thank you, Anne, for inviting me. I think this is a tremendously important event, and I hope it has some large effect. Now, I'm just a law professor. I guess I'm not the only law professor here, though. And as you all know, we like to ask questions, not answer them. It actually makes teaching a lot easier. So I'm meant to talk about faculty misconduct and in research in particular. And I suppose as a faculty member, I should be an expert in this, although I hope not quite in the misconduct. My only regret is that the misconduct we have to talk about today is not the really interesting misconduct, which is more on the personal side, but I'm glad I don't know about that either personally. We're going to actually talk about what's, seriously, actually the more important misconduct, because the personal misconduct merely corrupts youth and perhaps some adults. This sort of misconduct actually corrupts knowledge. And ultimately, that's of far broader significance. I just want to run through some of these cases as we would in a class, and then perhaps we can generalize about them afterwards. The first example we have concerns conflicts of interests. A guy called Nemiroff studies depression, and he's receiving money from GlaxoSmithKline. I hope they don't merge with another company. That would really be too much. To give talks, and of course some of these talks are just promoting its products. It seems a little sleazy, right? Just for starters. And it becomes particularly awkward because the company is making drugs for depression, which is the sort of thing he's doing research on and talking about. And these are subject to suit because people get hurt. The drugs are, to put it mildly, a little imperfect. And so my question is, what did Nemiroff do wrong? He receives about $800,000 for giving talks. There's no evidence that this actually altered his research. He has praised the company a lot, as you would expect for $800,000, but what did he do wrong? You won't find the answer there. It's like most cases from the Supreme Court. The answer is not in the book. It just isn't. We just have these facts, and they may be incomplete facts. I actually did some research last night, and I tried to learn more than what was in this book, because I thought it was a bit frustrating. There wasn't enough here, and there isn't enough on the web either. Maybe information was not published, maybe it got a little suppressed, maybe it just isn't there. So what do? Some guy gets $800,000 from a drug company on depression. He's writing on depression. The company gets sued on account of its depression drugs. A senator goes yakking about this.
So I want to just comment that if he goes out and he discloses at the beginning of his speech, I am being compensated by Glaxo, and by the way, this is what I think, I just question whether there really is a problem altogether.
Is there any problem then? Disclosure fixes it, yes?
I think it's the appearance of impropriety.
The appearance of impropriety. What's wrong with that?
No one really can trust you.
Oh, okay. And who loses from that? No one trusts Nemiroff. This guy is tainted forever, right? But the appearance of impropriety, how far are you going to take that?
It calls everything he's taught into question. So the students lose out on it. The university that pays him loses out because they've expected him to teach sort of in an objective fashion.
Yeah. So who has an interest in preventing this, at least appearance of conflict of interest? Nemiroff himself, but he actually doesn't care enough. For $800,000, he'll get over operational costs. Mind you, I don't think that's enough. Would you sell your soul for $800,000? I wouldn't, and it's a lot of money. Who else would care? The university should care. Its reputation is affected. Anyone else? Yeah. Your peers. Right. You're tainted by association with the man.
Whom I know Medtronic I know very well. They keep getting into this problem. The company itself actually does care at the end of the day, because their credibility in terms of their argument also starts failing.
Right. Does the federal government have an interest in this? I think that actually, it's worth pausing to think about that. Why is Senator Grassley so interested in this stuff? Well, other than votes and money. Yes. Divergence.
The federal government provides money through the NIH and the various other organizations, and obviously it assumes that in providing the money, it's giving it an imprimatur of being an objective study. So if you put Glaxo money into the same pot and say, go have at it, and in fact it's an entirely different set of criteria, that's problematic for NIH.
So how does the federal government protect its interest in the appearance of propriety, indeed the propriety ultimately of the research? It gives money, right, we all know the system. We actually have what you'd call a cascade of agency, right? The federal government gives money to universities. It channels all of its research money to universities. The universities then give money to the professors. And the federal government asks universities in exchange for this funding to place restraints on the professors. And I'm going to talk more about that later in about an hour from now. That makes, by the way, notice this makes universities federal agents for policing research. And it makes the faculty agents of the university. And if academic freedom is one's role as an independent agent in research, i.e. not someone else's agent, then perhaps academic freedom is affected by this, important as the interests may be. Actually, there's a lot at stake in this, and this gets back to your comment. Perhaps there's nothing wrong here. By the way, do we know that anything is wrong here other than the mere appearance of impropriety, which the federal government doesn't care enough to regulate directly, which it may not have the constitutional power to regulate directly, and therefore ask the universities to do, thereby evading the First Amendment? I don't know. I mean, it is quite striking. If the federal government really thought there was a problem, why aren't they regulating it?
I have a question. What are the government rules under which he's taking the grant? Can he take anything else? I mean, usually the government does have a policy on that, doesn't it?
That's right. So NIH and the National Science Foundation, when they issue grants, ask universities to establish a conflicts of interest policy. And what he actually did that was technically wrong, and here he was wrong, is he should have reported his outside income to the university. And it's perfectly reasonable for universities to want to know about somebody else's outside income. So he did violate university rules. Does this deserve a federal? But what else did he do that's wrong? He may actually be a superb scientist. I don't know. We don't have to linger on this. I just want to point out, this is actually a very complicated problem. Of all the problems we're going to talk about today, I thought this was the most complicated because it's not obvious what he did wrong, and yet there's something problematic about it. And it's just very hard to put one's finger on it. It's not actually technically a violation of his conflict of interest vis-a-vis the federal government or the public, only vis-a-vis the university. And the danger is the university policy is actually a federal policy imposed by condition. Yes.
One of the things that I think a lot about is that when I entered the investment banking business, no one would write a memo on funding a casino company or a tobacco company. Why? We have plenty of investment banking firms. Everyone knew you didn't do it. It seems to me that we need to build some consensus on what you do and what you don't do, all of which doesn't get taught in college or university. And I'm a venture capitalist. We have to have that in our business. And we're getting kids that are coming in that are just totally unprepared in college to enter business. It's just unbelievable.
Yeah. No, I quite agree, actually. I was told earlier that I was forgiving. It was the one thing I dissented in from that wonderful speech by Benno, which is that I'm forgiving of faculty. Actually, I would describe these institutions as beautifully designed to destroy all attachment to God, country, and family. You put in the child, it goes through the meat grinder, and they leave being critical, taking a critical stance of everything, as if the rest of us are uncritical. Yes?
Actually, we talk about the 1940 statement. It was one of the few duties that actually is specifically in the 40 statement. Research for pecuniary gain should be based upon an understanding with the authorities of the institution. So that was a heavily negotiated term going all the way back.
That's right. And he clearly did violate his duty to the university. The only reason I raise questions about this is what are the legal repercussions outside the university? Anytime you have a senator asking questions, there are concerns as well as perhaps sympathies with what he might be arguing.
Phil, I want to answer your, or at least address your agency question, which you threw out on the floor. If I'm a research scientist and I'm getting money from DARPA, or I have the opportunity to get money from DARPA, I'm under no obligation to take that grant. I'm not being coerced to take it, or money from the NIH, or from Smith, Glaxo, whatever. So in the sense, if I choose to do that, I'm a free agent, but then I know that I'm being an agent for the government or for the university. So I don't see that necessarily as a problem, unless the only way, this is where it gets problematic, is not in the theory but in the practice. If the only source of funding for the kind of work that I do comes from the government, I have no choice but to take the money, and then my integrity may be suborned.
There's a real problem here, that's right. All of this is done freely, and everyone's very grateful for the money. Frankly, you're not going to get ahead in the sciences unless you get money for your lab. But what's interesting is the government has turned the universities into mechanisms for doing government research. Our entire method of testing new drugs and devices basically co-ops private institutions. That's maybe not a bad idea because there are a lot of good people there, but at what cost? And I don't have an answer to, I don't want to pretend I have an answer to this. I don't want to be dogmatic one way or another because quite frankly, on the one side, there's academic freedom, the freedom of the faculty. On the other hand, there is this entire system and its integrity is profoundly important. I wish we could go back to the situation that Charles talked about in which individuals had internalized these ideals and would refuse the money and would be straight on their own. And the danger is, and this is something Tocqueville recognized, as you move towards a society where people have not internalized this, where they're not religious, don't have any alternative set of morals that keeps them on the straight and narrow, then government has to come in. And so inevitably one slides towards that soft despotism. I wish I had an answer. One more and let's move to the next topic.
Well, I'm still having trouble.
Okay.
Because if I get up there and I'm this professor and I say, I'm being compensated by this company, and then I tell the university I am being compensated by this company, then everybody has been properly warned, there's been proper disclosure. I don't understand why there's even an appearance of me doing anything wrong. So my question to you is, first, what actually happened here? Did this fellow, when he started his speech, say, I am being compensated by Glaxo? And then did he go ahead and tell the university, I'm being compensated by Glaxo? Because he did. If he did, I can't see anything wrong with this, and maybe I'm just not viewing this properly. But I put out the question and ask it.
I do not know what he said in front of each speech. I do know it is clear that he did not inform the university as he probably should have.
So if he had done that, would he have been, acting properly, or is there more that he should have done, like not accept the money?
Good question.
This is what I don't understand.
Yeah. And this is actually, I think, the crux of the moral question, isn't it? Because once he discloses, that actually solves the conflict of interest problem. There remains an issue as to whether or not you take money. So, for example, I'm very involved in some of these disputes involving institutional review boards. I don't take a penny. I will not take a penny for anything on it, precisely because when push comes to shove, and it will in a few years, I'm going to be the only one in the room who said, I've not taken hundreds of thousands of dollars for this. So I do think morally it matters to refuse money, but has one violated conflict of interest? I think you're absolutely right. He hasn't if he discloses.
That's an individual choice.
That's right, a
You-
purely
I
individual
choose
choice.
not to receive
That's
money.
right.
That's an individual choice.
That's right.
But that should have no reflection upon
That's
whether
right.
he's done the right
Right.
thing from
And
my
the,
perspective.
and the larger problem here maybe we're just singling out corporate funding for this sort of severity. Do you really think public interest funding or religious funding or government funding doesn't influence people? That should be a conflict of interest too. I want to change topics, if you don't mind, because we have a bunch of them here, and I know I'm probably running out of time. I want to talk about research fraud. So there was a lovely case here of Michael Ballil. Michael Ballil wrote a book called Arming America, in which he discovered, astonishingly, that early Americans didn't really love guns. They didn't have many guns. They scarcely knew how to use guns. Who thunk it? The folks who fought the American Revolution didn't have guns. And the response from academia was heartwarming. Everyone, it was actually like a religious experience. Everyone raised their hands and said, hallelujah. Amongst other things, I mean, Ed Morgan, a very sensible historian, very distinguished gentleman from Yale, he wrote and he praised this book. And the Columbia History Department, my own university, gave him the Bancroft Prize. That's as good as it can get. So my first question, before we even begin to discuss what went wrong, why did they do this? Or is it just a silly question, isn't it? It's a very silly question, isn't it? No? Why did they do this?
What are they being educated to think about in terms of their own research? Are they being educated to selectively pick data to create research that supports hypotheses lovingly acquired, K through 12 and upward? Or are they indeed ever taught to, these days, critical thinking so that they can choose between A and B? Do they have such blinders that they just can't investigate anymore?
I worry about that same question every day.
What about the book award committees? I mean, who's in charge and vetting these
It's the entire Columbia History Department. And you notice they're a great department. It's said to be the best department in the United States.
A bunch of free thinkers, obviously.
Well, let's take it a step further just to press this point home. I happen to know a little bit about this case because it was one of my very, very best friends, Jim Lindgren, who broke it open. Jim is a very unusual man. This man is smarter than the rest of us. He's also bigger than the rest of us. He's larger than life in every sense. And he is an independent thinker. And he's very good at math, amongst other things. He's not an historian. He's a lawyer who has gone back to do statistics and is probably one of the best people doing statistics and law in the United States. So what does he do? He looks at this book and he just sees the graphs and he knows, looking at the tables, these don't work. Now, this is someone with a very fast mind. He does statistical modeling of a thoughtful kind. He just looks at them and instantly says, there's something screwy here. So he then reads it. He then starts doing historical research. Unlike the folks in the Columbia History Department, he went to Vermont. He went to New Hampshire. One of the funny things about this book is it cites all sorts of records from San Francisco before 1906. Guess what happened to those? You get the idea. They don't exist. These things don't exist. But of course, to prove this, you end up having to interview county clerks. Do these records exist? Are they somewhere else? Have you seen this guy Ballil? You've never met him before. Oh, how curious. Any case, to take the position that Jim did for over 2 years was actually rather awkward. People were furious with him. They denounced him. There was a lot of pressure of him to shut up. He had to be very polite and understated about it all. But in the end, they withdrew the prize. So my question to you is, if we're the Columbia History Department here, would you have voted to withdraw the prize, or would you have decided to leave it as a record of your ineptitude? No, seriously. I think it's actually a very interesting moral question here. Can you erase, can you get redemption just by removing it? What? Yes, it's a do-over, exactly. I don't want to say it's a form of fraud, but it is perhaps nor cover-up. They were disclosing what they were doing, but it's an issue. Okay, this is too easy, right? How about ghostwriting? Here's something a little bit more complicated. Dr. Bachman publishes an article praising hormone drugs. It's a very fine article, Sadly, she did not write it herself. It was supplied to her by a company, really a publicity company, on behalf of, oddly enough, a manufacturer of hormone drugs. What should her school have done to her? We know what she should have done, but what should her school have done to her? A little inquiry? And then what do? You fire her? Or just put her on probation for a year? That's easy, isn't it? I thought so too, but then I paused for a minute. So who else ghostwrites? Don't look at me. I don't hire research assistants. I want to actually do my own research as well as write my own stuff. But a lot of professors. What else? Let's get away from professors. This is getting too awkward. Every partner. That's right. Every judge. Those judges, those lovely judicial opinions, they vary year to year depending on the quality of the law clerk. Now, I don't want to say that all the judges don't write their own opinions, but it's a very real problem. And when you get into administrative law, don't believe for a second that the heads of agencies even read their opinions. We all are a little guilty, perhaps. So do you feel more forgiving? No, me neither. Me neither. The statistics here were very interesting, and I'm not going to have the time to dig it out, but it would be interesting to know how much of the ghostwriting is done by graduate students and how much is done by outside commercial firms. One might feel very differently. These are different levels of offense. But there's a very real problem in medicine in particular where there's the jointly written article, right? This is a problem. Okay, one more. Do we have time for one more? Let's go on to tenure. Also tenure. That's more fun than this.
Yeah, it's very similar to the. Yeah, I mean, where graduate students wrote a lot of Larry Tribe's books, Harvard did a very substantial inquiry. I think Derek Bach was part of the panel, and they decided that the amount of plagiarism that came in because the graduate students' notes on certain books were just put into Larry's book without any attribution that they weren't written by him or that they indeed came originally from another source. So that's the other side of the problem that Philip was talking about, is that you get into plagiarism when your graduate student takes notes verbatim based on a book, and then you lose that reference.
It's a nice excuse.
Yeah, I'm like Philip. When I was a law professor, I never used research assistants. It's just too easy to fall into unknowing plagiarism. Well, you just don't know how your research assistant does research, and that's the problem that I think often happens.
Fascinating material, and is typical for an ACTA event. We're going to put much more in front of you than you can assimilate at any one time. I want particularly to point attention to the questions that we've put at the end of each of the case studies. These are intended particularly for trustees to take back and think upon to guide their policy making. And it's with this topic of academic freedom and tenure that we particularly turn our gaze to trustees. In case study number 9, which concerns the tenure case of Casey Johnson, we see an instance in which it was the Board of Trustees that came to the rescue of academic freedom and indeed the career of an exceedingly important historian. And we'd like to look at that for a moment and then extrapolate the lessons. Let me first contextualize the whole issue of tenure. We're down now to less than 30% of the teaching force being tenured. As Benno Schmidt said earlier, tenure may die a death that has nothing to do with academic freedom. It may be a financial and economic death. It's unclear how many would lament that. However, for now, tenure decisions are exceedingly important. The public is pretty upset about this. As you'll notice in your book, about 82% of the public surveyed thinks that there's something very wrong with the tenure system. Again, let me draw your attention to page 93. Hank Brown, the former president of University of Colorado, John Cooney, a statistical psychologist, and I wrote an article on tenure and the absolute imperative of coming up with transparent procedures that the public can believe in. For as long as it's financially viable, either we improve it or its death is going to be quicker and more certain. So case study 9 in brief. Casey Johnson publishes 2 books with Harvard University Press, 3 volumes of the Lyndon B. Johnson tapes, is known as an outstanding teacher, and his colleagues want him deep-sixed because of a lack of, quote, collegiality, which had to do with his objection to a totally skewed panel on the September 11th attack on the United States. Public outcry, including that of important historians around the country, brings us to the attention of the Chancellor and the Board, and it is the intervention of the Board that has the case completely reviewed, and Casey Johnson is now tenured, continues to be an exceedingly successful teacher. The only reason he's not here today is that indeed he had a class to teach and would not give this priority, would not even give ACTA priority over teaching his class. So we come to the first question, and let me bring Philip back into this discussion. What is the role of the Board in ensuring a transparent and fair process that is not subject to either personality whims or, even worse, political and ideological pressure? How does the Board meaningfully set and enforce tenure policies that work?
Michael, I think that is an impossibility. I've sat on a NESCAC, Small Liberal Arts College Board, for 23 years, and we had tenure review where we had to approve tenure decisions periodically. And I promise you there wasn't a member in that 36-member board that had a slightest idea of the qualifications of the applicant. It was just a rubber stamp, bang. To really do that job, you would have to do a lot of research and a lot of investigation and a lot of careful analysis from peers and others to know whether this is really deserved or whether it's just a political appointment.
If I could ask one very brief question, what kind of summary did the trustees see of each case? Was it a paragraph? Was it a page? Was it a 5-page summary? Typically, a tenure file will be about 3 volumes large. It's a too much information file. I was an academic vice president, and of course what the faculty loved to do once in a while was go to the board and say, do you want to read 30 of these at every board meeting? And the trustees would say, no, please, we'll depend on the chancellor. Where is the due process, and what is the structure? Is there indeed a structure that could work? Let me call on Chuck Stetson.
This seems to be a classic in governance. In the corporate world, you have subcommittees like an audit committee and all that. Why isn't there a committee? It seems to me this is the responsibility of the board, but you could have a subcommittee that reports up to the full board. But if you're not doing this kind of review, the trustees aren't doing their job, in my view. I think it's a governance issue.
There's a very interesting problem here because, on the one hand, the professors are the ones with the knowledge. On the other hand, it may be those who are, apart from the professors, who have the dispassionate attitude. And the question is how you bring these together. I'll just tell you one actually sad story. My brother teaches medieval art at Harvard. He's a very, very learned man. And you have to learn dozens of medieval languages for starters. And at Harvard, of course, it's the president of the university who joins in and sort of finally decides who gets tenure. And So you can imagine what happens when you take a bunch of medievalists trying to talk about why you should hire someone who's working on some obscure manuscripts, not to criticize my brother, talking with Larry Summers, who has a distinct opinion about 14th century Flemish. But of course he doesn't, and he can't really. And that's not to deny his intelligence and his serious concerns and the role of oversight. The question is how you bring these things together. I'd like to throw out just another possible solution to this. Given that at the oversight level, one cannot judge the 14th century linguistics, but one can perhaps have a smell for political discrimination, religious discrimination, and the rest. There is the question of funding. Maybe the oversight boards cannot get involved in each decision on hiring, but perhaps in allocating funds, one can reward departments that do well, that are at the top of the field, that are open to different points of view. There's a lot of room, at least, for oversight.
It would seem to me you could ask some questions, couldn't you? You could have the oversight board ask questions of the various departments and say, why are you recommending this person? You know, what did you find out? You know, summarize before me in 15 minutes, you know, these 3 volumes of stuff. I mean, this is kind of very natural stuff, but it doesn't seem to be clicking in.
I was the chairman of the CUNY board when the K.C. Johnson affair came up, and if you like, I can kind of run you through my thinking about it. In the first place, it was within the history faculty of Brooklyn College, which had denied Casey at the tenure recommendation. Dissenters from that brought to our attention that that in the process of discussion, a lot of weight was given to the fact that K.C. Johnson opposed certain other faculty members' views about the importance of affirmative action in relation to some other appointments that were under consideration, and he took the position it should be the academic merit only, and that if someone didn't come in at the top of the list, merely the fact that they were a woman should not be given weight. So there was evidence that the process had been infected by considerations having nothing to do with his scholarship. Then we had a whole group of historians, CUNY graduates and people from the CUNY faculty, Don Kagan, Gertrude Himmelfarb, several others, who wrote us to say that K.C. Johnson's books and so forth added up to actually the most distinguished body of scholarship on the Brooklyn College history faculty, and that it was laughable that these less distinguished people were denying this guy. By the way, hardly a conservative, he's sort of Clinton Democrat, and yet within the Brooklyn College history faculty, you know, that seemed way, way off to the right. So what I did was first, I thought the board should never get into making an independent appointment that doesn't come from the faculty. But if the board is reviewing a decision by the faculty not to proceed with tenure, and it doesn't pass the smell test, the board can constitute another way of reviewing it, not avoiding review. But what we did is we got a number of distinguished history professors from the Graduate Center who had no connection to Brooklyn College, whatever, and there are some very distinguished ones over there, as you know. We put together a special committee that reviewed the whole matter and came back to the chancellor with a recommendation that K.C. Johnson scholarship and teaching, he's a great teacher, more than met the tests for tenure. And the chancellor and the board, we decided, all right, we're going to follow the advice of this independent group we constituted, whom we trusted, and we made the tenure appointment at the board level. And I think we were right to do that. I don't have any doubt. If a board smells that politics has infected the tenure process of somebody, they should get into it and make sure that the academic merits are what takes priority. And that's what we did, and as a result, we have this very distinguished historian over at Brooklyn College.
You are talking about a single case
Right.
of somebody obviously quite distinguished and although controversial. And if I may go back to my experience again, when we got tenure review, when it was put before the board, there was usually 6 or 8 candidates that were being considered at the same time. And we didn't get a paragraph, but we got 2 or 3 pages, basically what they'd written. That was their documentation that we were supposed to rely on. And I promise you, we had not the slightest idea of the qualifications, nor was there any effort made by either the administration or by members of the department who were recommending tenure for these people to come to that board or come forward and make a statement of support.
I was going to say, Casey Johnson benefited from 2 things, which is fortunate. One, he wasn't on the right. And second, he's a great teacher. And as a result, students came to his aid and sort of overturned it. The terrible fact is, though, that most of us academics are not great teachers, and we're not great scholars. Hopefully we're just good. And we can't hope to be geniuses. And one can hope, but it's silly, isn't it? And most of us get over our vanity at an early age. So what happens to those academics who don't have that advantage? I want to raise an example that Benno knows. It was not during his time at Yale, that of Tom Pangel.
Yeah,
Tom Pangel was a Straussian, which, by the way, in case you don't know, theologically is a worse sin than anything identified by the Catholic Church. And Tom Pangel was a great teacher. And Tom Pangel was a great scholar, a very learned man. He ran into a little difficulty because in the political science department at Yale, teachers were going around, colleagues, distinguished, well-known political theorists were going around saying, free speech is all well and good, but of course not for Leninists or Straussians. Now, why you put these 2 together, God knows. But so students knew this, but students were afraid to testify about it because they knew that if they spoke up about it, did more than in whispers to 1 or 2 other colleagues, they knew that their chances at a job in academia would just disappear into smoke. And so so even in a case such as Pangel's, there wasn't enough oomph there to overturn the departmental prejudice. So I think this gets actually back to the question of individual morality and individual integrity. These systems, you can have all the formalities in the world, but they can't overcome personal failure. And in that sense, I fear we get the universities we deserve, and the universities just accentuate and accelerate the process by which we get the society we deserve. And that's really sad, because I'd hoped for something better, and I'm not sure the institutions can function unless there's certain personal integrity. I don't know.
On that point, yeah, Casey had the great advantage of having some top leaders who, in fact, had internalized integrity, as you so well put it. This raises the larger question, or rather the big picture here, the systemic question. We have governors on many occasions who lack integrity, and they put in trustees who lack integrity. Those trustees go on to put in chancellors and presidents who lack integrity. They, in turn, put in deans and deanlets and grant tenure and so forth to deans, to all of these people who lack integrity. So there's really a breakdown in such integrity from the top down, at least regarding the big public systems. It seems to me that reformers such as this group here, that we have to start thinking about radically challenging the system itself. What are the motivations for all of this? What is the role of governors in appointing trustees? I mean, it really is not as simple as a trustee in a small college or one university taking action. When that person goes, the sands will fall upon it once again. The seas will come back in, and it's a drop in the ocean, and it goes away. significant reform. So it seems to me that we have to look at ways in which we challenge the system. For example, the role of federal money in all of this, the role of political funding, exchange of favors, etc., boards, trustees, presidents, politicians, and the role of all this. In other words, it's really quite stinking from the top down.
I just want to note we've only got a couple of minutes before we move on to the panel. I just want to raise one point. We won't have a chance to go over it. We talk about the possibility of a second bite on the apple, page 98. One of our recommendations is enhancing the post-tenure review process. And as we talk about particularly issues like research misconduct, which is something that tends to surface in large measure with senior faculty who have already gotten tenure, the post-tenure process does offer certain opportunities for an active board to enhance the whole issue of ethics and participation in a vibrant peer review process. So again, a little bit of outside reading that we won't have a chance to go over. The recommendation section in the book throws that out as a challenge for boards. I think our last comment will have to be from Mr. Ryan.
Thank you. I just want to follow up on what Candace was saying. And I've been on my university's board now for about 6 years, and I rarely hear the word fiduciary responsibility. I'm on a subcommittee for pension to overlook our TIAA-CREF investments. That word was brought up as a real serious issue. We hired an outside attorney to advise us. But I'm hearing this fiduciary responsibility, and I hear calls saying, yes, we got one paragraph, let's vote on it. These are all the candidates. And I don't want to accuse my board of just rubber stamping. The president does, and I know Mr. Benito, you do the same thing. You share with the board, and the board all goes, yes, we asked a few questions. Okay, all in favor? Aye. And I'm sorry, after 6 years, I have yet to hear one person say no. So I'm concerned. I mean, I'm interested. I was telling my colleague here, Christopher, 2 seconds ago, that I'm really happy that ACTA is looking at this issue. What prompted ACTA, of all the issues facing higher education today, to focus on this? So I want to thank everyone, ACTA, for bringing this issue. But I think if we are going to leave today, I think we have to understand better what our fiduciary responsibility is. And as you were saying a few moments ago, an active board, I think Benito would recognize, Professor Johnson would always come to the attention of the board because he will speak up loud. But there's 99 of the other 100 professors don't have that audacity to come forward and say, I object.
Thank you so much. And that's a very, very good word on which to wrap up this session, fiduciary. Trustees as the guardians of the faith of their universities and the nation, and their obligation to be active, not passive. Let me thank Professor Hamburger so much for leading the session. Benno Schmidt.